Hey everybody, welcome to another Crypto Beast stream. Can I get a confirmation please from somebody in the chat that this is all coming through loud and clear, no video, no audio problems? Hey Dr. Dorkmeister. Hey Mousy, can you guys hear me okay? Just wait till I can get some confirmation that it's all working and good. Okay, great. All right, well, let's get into it. I've got a hard stop in a couple of hours. I've got a big meeting today, but hopefully we'll get through this long before then. All right, so... a lot going on in this case in the Southern District of New York. I'll start off, I guess, with this tweet. September 19th, 2019. Breaking news. The judge in the Southern District of New York rules on Dave Acton's suit against Jason Goodman. Did the case get tossed out and Dave hit with huge financial sanctions, as was reported by Marcus Conti and DeFango? Or was that fake news? Well, obviously that was fake news. I don't know if you guys remember, but both DeFango and Marcus said that the judge had tossed this case out of court and that Dave was facing these massive financial sanctions. And this is just completely false. The case is ongoing. There's no sanctions. And in fact, there's been a recent ruling about it. So we'll start with this ruling, which is from the Magistrate Judge. So what happened, just a brief history of this case. Basically... it's a defamation case. Jason Goodman is facing a couple of them. He's got Robert David Steele, sued him, Trish Negron, and Queen Tut in the Eastern District of Virginia. And then later on, Dave Sweigert, sued Jason Goodman in South Carolina. And South Carolina, of course, is where they pulled their Operation Clear and Present Danger. Dirty Bomb Mask Memphis, where they used a YouTube live stream to shut down the port of Charleston for about 8 hours. And at the time, I think it was the 8th busiest port in the United States. So the case was filed in South Carolina. There are a number of updates, and then it came to light that the information behind that LARP, that there was a dirty bomb made from uranium on the Mask Memphis, came from their source known as Rock Hudson or Mr. Hudson or Deep Uranium, who appeared and featured in multiple Crowdsource the Truth episodes. And it turns out that guy is actually called Okie Marshall Richards Jr., and he is an FBI contract informant, meaning that he's been paid by the FBI, kind of like a provocateur to set people up. So the information about this case was originally potentially coming from the FBI, and so that was brought up in court by Dave Sweigert, and immediately they ruled, we've got to change the venue for this case. And so it was moved out of South Carolina to the Southern District of New York, and it was assigned to this judge, Valerie Caproni. Now, she was the general counsel of the FBI, appointed by Robert Mueller, right? So as soon as it came up that there was FBI involvement in this case, it's basically sent to what looks like an FBI judge. And it seemed like the case was kind of stalling and going nowhere, so Dave made a lot of noise about, hey, we may be going to have to appeal, and this isn't going to look that great on appeal, the way this case is being handled. And so then the case was passed on to Stuart Aaron, who's a magistrate judge. And so the magistrate judge has been looking at the case, and he's basically made a report and recommendation and order to go back to Judge Caproni about how the case can proceed. So I'll run through that quickly, and then Dave has objected to this case, and I'll be going through his objection. So pending before the court are the following motions. Motion by defendant Jason Goodman to dismiss the second amended complaint filed by the plaintiff. Okay, motion to dismiss, pretty standard. Then the plaintiff's motion to dismiss the counterclaim verified complaint filed by the defendant. So Goodman has gone and filed a counterclaim saying that in fact it's Dave who has defamed him, and he's entitled to money for Dave's defamation. And we'll be going through that in some detail. Then there's the plaintiff's motion to add Marcus Conti as a defendant, and plaintiffs led a motion to amend the second amended complaint. Plaintiff's motion to add Kerry Wolf, which is the all-seeing you, as a defendant. And there's a strong suspicion that both Marcus DeFango and all-seeing you were involved in making these Dopey Dave videos, which are almost like snuff films being put on YouTube as part of the harassment going on here. And then non-party Conti's motion to intervene. So Marcus Conti has filed a motion to intervene in this case, and one of the interesting things is he there's no reason for him to do that. He voluntarily did it, and he put in a document, where he's making these statements under penalty of perjury, which means that he can go to jail if he says something false. And in his motion, he said that Dave Sweigert and Thomas Schoenberger are business partners. Now, that's completely false. So he could go to jail just for that claim. Now, I actually have evidence from both of those parties indicating that they don't know each other in any way. I've got Dave asking me about June last year, I think it was, who's TS? I mean, if that's his business partner, why doesn't he know who the guy is, right? So there's plenty of evidence to basically debunk that, and Marcus is potentially in a lot of trouble. Dave has said that his intention is to sue Marcus in the Eastern District of New York now, which is Brooklyn, where he lives. And then finally, the seventh thing, plaintiffs led a motion to add counts of mail fraud and wire fraud against Conti. And so the recommendation is the motion to dismiss the second amended complaint be granted in part and denied in part, and we'll go into that in a bit. The motion to dismiss the counterclaims granted in part and denied in part, and that the motions to add everybody else get denied. So that's basically partial win for Dave and a partial win for Goodman in this recommendation, but this is what Dave's objecting to in his latest filing. So, just scrolling through this to see if there's anything of particular note here. The Caproni kicked out the RICO aspect of the claim for failure to state a claim, but she said that he may be able to assert some plausible claims in a properly constructed complaint, and gave him 21 days to amend his pleading, which he did. And in the second amendment complaint, he's saying that Goodman, via Crowdsource the Truth Properties, has purposely and maliciously engaged in defamation per se, libel and slander against Dave using continuous non-stop weekly broadcasts on his CSTT-branded social media outlet that feature perverse images of Dave, allegations of criminal conduct, and so on. And he further alleges that Goodman used Dave's likeness to sell coffee cups, tote bags, t-shirts on the merchandising site Redbubble. And then he's making 4 claims against Goodman. One is a claim under sections 349 and 350 of the New York General Business Law, which is basically, you're not allowed to run a business that's malicious and misleading and lying to people. A claim for defamation and defamation per se. Defamation per se is things like, when DeFango and Doug Stewart say that I'm responsible for the fires in Australia, which killed 31 people and about 1 billion animals. That statement's defamation per se. Just to accuse someone of murder is defamation, right? Just in the face of the statement. So that's sort of what they're saying there. A claim under sections 50 and 51 of New York Civil Rights Law, and a claim for negligent and intentional infliction of emotional distress. And we're going to be drilling down into this one in particular, because it's kind of key to not just this case, but really like the bigger picture of what's going on here is that, can these LARPers on YouTube just do whatever they want? Can they shut down ports? Can they incite mobs with hashtag campaigns to cause disruption to critical infrastructure? Can they lie about people and accuse them of crimes and have no consequences and never get into any trouble? And it's an area where I think the law is kind of struggling to catch up with the technology. That we've had YouTube for quite a while now, like, 2005 maybe, 2006 it came out. And these cases are just starting to hit the courts and the Court of Appeals, which is where, legal precedent gets set that helps to define these laws. So, I consider this a very important case. on the internet, and freedom of speech is one thing, but you shouldn't be able to just lie about people and just accuse them of crimes without ever being asked to present evidence. So there's Goodman's counterclaims, and he's asserting defamation, aggravated harassment, and civil conspiracy. And he's basically mirroring whatever claims Dave's made against him, he's mirroring in his counterclaim. So classic, projection there, projecting onto others all the crimes that you commit yourself, Alinsky tactics. So there's a motion to dismiss. I don't think we need to go into the all seeing you and Marcus things. They've been kicked out by the judge. So here, as the plaintiff proceeds pro se, the court must construe his complaint liberally and interpret it to raise the strongest arguments that it suggests. However, this does not exempt the pro se party from compliance with relevant rules of procedural and substantive law. Now, Dave's filings, they cite precedent and case law, and he seems to me to make a very clear case for the legal basis of what he's doing. And as we'll see going through this, Jason Goodman's filings don't do that at all. And the pro se litigants are generally required to inform themselves regarding procedural rules and comply with them. So here's the sections of New York law. Section 349 prohibits deceptive acts or practices in the conduct of any business, trade, or commerce in the furnishing of any service in the state. So basically the plaintiff has to allege that the defendant's practices had a broad impact on consumers at large. And the plaintiff alleges defendant misled the public, and that defendant engaged in deceptive business practices as part of a ruthless quest to harm the plaintiff and disrupt every aspect of the plaintiff's life. The courts found that this alleged conduct falls outside the ambit of the New York law, even assuming that conduct is what that area of the law was supposed to protect. The injury is private, so it's not something that's injured consumers at large, it's injured the plaintiff specifically. So they're recommending to kick that out. And then to state a claim for defamation under New York law, the plaintiff must allege a false statement about the plaintiff published to a third party without authorization or privilege through fault amounting to at least negligence on the part of the publisher that either constitutes defamation per se or caused special damages. And special damages consist of the loss of something having economic or pecuniary value, which must flow directly from the injury to reputation caused by the defamation. And so one of the arguments being made by the plaintiff here is that basically the ongoing campaign of slander allegedly conducted by Goodman has been targeted at his career. And if you look at some of the shows that Goodman and David Hawkins have done, saying things like, Dave, well, he's an EMT and he's got experience as a ham radio operator, therefore he jammed the radios on 9/11 and all of the firefighters who died were because of his actions. I mean, this is absolutely ludicrous. There's never any evidence presented for this, but it's obviously targeted to hurt him in his career as an EMT. We also have alleged behaviour of Jason Goodman calling up Mount Shasta and trying to get Dave fired from his job, where he's actually, I think, a volunteer, so harder to get fired, but still career damage. So special damages must be fully and accurately stated with sufficient particularity to identify losses. And then a plaintiff alleges defamation per se and thus doesn't need to allege special harm if the false statement of fact charges the plaintiff with a serious crime, tends to injure the plaintiff in his or her trade, business, or profession, imputes to the plaintiff a loathsome disease, or imputes unchastity to a woman. Hey Michael, Ben Mac, Lee, BB Rebozo. So in the present case, the plaintiff claim refers to a hodgepodge of screenshots, links to internet pages, texts of emails, and purported transcripts of video content that plaintiff alleges are defamatory. And the second amended complaint contains statements made by the defendant to third parties which state that the plaintiff is mentally ill and has engaged in criminal activity. So the plaintiff isn't alleging special damages, but asserts that that's defamation per se, and then construing that in the light most favourable to the plaintiff, he has adequately alleged these statements. So basically, the motion to dismiss gets denied. This gets to go forward that, defamation per se has been rightly alleged under the law in the eyes of the magistrate judge. And then the New York civil rights law. The New York does not recognize a common law of privacy, but it does make it a misdemeanor for a person. So this is misdemeanor means criminal, right? For a person to use for advertising purposes or the purposes of trade the name, portrait, or picture of any living person without having first obtained the written consent of such person. So basically, to make coffee mugs and to put Dave's face, Robert David Steele's face, and DeFango's face on these coffee mugs, and then selling the mugs for profit, but also running your channel for profit, seeking people to subscribe to your Patreon and your Subscribe Star, or to send Bitcoin or whatever. This is basically using somebody's likeness for the purposes of trade and commerce. So, to me, this seems pretty clear. The prohibitions are to be strictly limited to non-consensual commercial appropriations of name, portrait, or picture of a living person, and they prohibit using that for the purposes of trade. So the plaintiff has to prove that that's been done without consent and within New York, and the amended complaint does show pictures of it, and it references podcasts. So, accepting the factual allegations of the second amended complaint is true, court finds that, yep, plaintiff has stated a claim, and once again, the motion to dismiss by Goodman gets denied. Now we get to an area of dispute, which will be brought up, hey Pyramid 7, which will be brought up in Dave's document in a second. But the intentional or negligent infliction of emotional distress, it has to satisfy an exceedingly high legal standard. Of the intentional infliction of emotional distress claims considered by this court, everyone has failed because the alleged conduct was not sufficiently outrageous. The tort may be invoked only as a last resort to provide relief in those circumstances where traditional theories of recovery do not. And then the party alleging it has to prove conduct so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency to be regarded as atrocious and utterly intolerable in a civilized community. I mean, I think accusing someone of being responsible for 9/11 without any evidence, without even any logical basis in the claim, is atrocious. That is utterly intolerable, and it is beyond the bounds of decency. And there have been so many more accusations that have been made against Dave in this case. And then the elements are a breach of duty owed to the plaintiff, which exposes him to an unreasonable risk of bodily injury or death. So extreme and outrageous conduct is also an element of negligent infliction of emotional distress. So they're saying that, these videos linking the plaintiff's father and his invention of the cordless phone to the murder of John Benet Ramsey, since the father used a cordless phone to call the police, says regardless of how ridiculous and or insulting the defendant's statements about the plaintiff and his father may have been, the court finds they do not form the basis for a claim for intentional or negligent infliction of emotional distress. So they basically, the magistrate judge is saying there's traditional legal theories available, such as defamation, for these statements, and he hasn't met the exceedingly high legal statement. And the conduct has not exposed him to an unreasonable risk of bodily injury or death. So they recommend that basically this gets dismissed. The defendant's motion to dismiss the plaintiff's fourth claim. I guess what he's trying to say there is actually he's granting the motion. Hey, Mark Smith. So, look, I think we can move on from this. I'll provide links to all of these documents. Most of it's up on at Leopard Moreau's, but that's basically the judge's recommendation. Jason's motion to dismiss gets kicked out, but they're going to let Jason's counterclaim stay, and they're not going to recognise the intentional infliction of emotional distress component. So now we have document 139, which has just been filed, and this is the plaintiff's opposition to the magistrate judge's report and recommendation. So, as you can see, table of contents, there's the civil conspiracy claim, the intentional infliction of emotional distress claim, undisputed facts about the black cube coffee cup, the red bubble designs, and the continuous conflating of the plaintiff with co-conspirators. And then there's a legal argument, one, failure to provide plaintiff with adequate notice, which basically means that, Goodman is saying that Sweigert did all this stuff, but he's not actually stating specifically what stuff he did. Which, how can you defend yourself from vague assertions? The bulk of defamation claims are time-barred, which means there's a 12-month statute of limitations on defamation claims in New York, and so the counterclaim arguments are outside of that. And then the IIED claims based on smear campaigns have been upheld in this district. And this is an amazing coincidence in this case, because as you know, there's a certain little hobbit from Carson City that's completely connected to all of these cases. The Eastern District of Virginia case, the Southern District of New York case, and the various cases involving Ed Butowsky versus the Seth Rich's family. And one of the cases, which is the Riches versus Fox News, is being heard in New York. And there was an appeal. It went to the Second Circuit Court of Appeals, and they specifically upheld claims of intentional infliction of emotional distress. So he's actually citing here, as his legal argument, the Butowsky case. Once again, that's setting the precedent for this Sweigert v. Goodman case. As you see there, Aaron Rich versus Ed Butowsky and Matthew Couch, Bauman versus Butowsky, Butowsky versus Gottlieb, Rich et al. Versus Fox News, Rich v. Butowsky, Rich v. Fox News, Steele v. Goodman, which is the Eastern District of Virginia case. So, and other authorities and laws, as well as we've got some references here, mainstream media articles about these cases. The Daily Beast, Fox News reporter and right-wing conspiracy theorist plan to wiretap family of slain DNC staffer Seth Rich. And then we've got the New York Times, how a conspiracy theorist call about a dirty bomb shut down part of a port. And CNN, how a conspiracy theory closed part of a major US seaport. So we've got both the New York Times and CNN calling Jason Goodman a conspiracy theorist and saying that his wild conspiracy theory resulted in the closure of a port. But as you see later in these documents, Goodman's actually claiming that the people who say that about him are defaming him. However, he's not suing New York Times or CNN for defaming him, and it seems like pretty reasonable for any person to quote those respected mainstream media sources. It's not malicious if you're just repeating something that was in the New York Times. And then we have this one, right-wing activists discuss wiretapping Seth Rich's family, 3 people in the room say. So it's basically not being disputed that this was discussed in the Butowsky meeting by DeFango, Well-Traveled Fox, and Thomas Schoenberger. They're pointing the fingers at each other a little bit of who actually said it, but it's pretty much accepted that was said and that was discussed. So nasty stuff going on in all these cases related to Seth Rich. And of course, Seth Rich was, allegedly the DNC leaker who leaked emails to WikiLeaks. That's kind of the basis of many of these cases. And it's amazing how tied up these former DNC operatives are to all the stuff that's going on in mainstream news events. So, preliminary statement. The judge releases report, and he's noted these Federal Rules of Civil Procedure, Rule 8A, is different from New York State's heightened pleading requirements. But it can act as a two-edged sword. Relaxed pleading requirements for the defendant and adequate notice requirements for the plaintiff. The plaintiff is entitled to adequate notice of plausible and coherent allegations, as provided by the Federal Rules of Civil Procedure. And the situation is prejudicial to the plaintiff because this rule requires him to get adequate notice of the defendant's claims so that he can prepare a defense. And that's why he is objecting. And then he's also objecting to the recommendation that the intentional infliction of emotional distress claims be dismissed. And specifically the statement that defendant's conduct has not exposed plaintiff to an unreasonable risk of bodily injury or death as required to state a claim for negligent infliction of emotional distress. Now, Dave is a military veteran. He served in the United States Air Force, and he was in a peacekeeping mission in Nicaragua in the early 80s, where the helicopter that he was flying in crashed, and he was imprisoned by the Sandinista guerrillas for a couple of days. Obviously, an extremely traumatic experience. I think there's arguments can be made that he was tortured while he was imprisoned, and basically, what he's arguing, and I think he's very right to say so, is that Goodman's conduct and action in targeting him over this area where they know that he suffers from PTSD is designed to trigger his PTSD. Although it's bad with coronavirus, right? Everyone's freaking out about it, and 22 people allegedly have died in the United States from coronavirus. Every day in the United States, 22 veterans die, right, from suicide related to PTSD. So this is not a made-up thing. This is an epidemic. It's a much worse epidemic than coronavirus. It's very bad, and I'm sure Jason Goodman is aware of that. And I don't buy the argument that anything Jason Goodman did to Dave Sweigert is newsworthy. If you just go back and look at all of the episodes, dozens if not hundreds of these episodes, the graphics they make, the false information that they spread, it's really honing in on how can they do maximum damage. How can they hurt people the most? Just like when Goodman and Jan Irvin doxed my wife, it's got nothing to do with anything I've said. It's got nothing to do with the truth or the news. Doxing my wife is just a deliberate attack on my family. So that's how these people operate. So here's the grounds on which the plaintiff objects to the statement. Under New York law, hey, John from We've Read the Documents is here. Big star. G'day, mate. Welcome. Under New York law, the standard of outrageous conduct is strict, rigorous, and difficult to satisfy. That's not the case when there is a deliberate and malicious campaign of harassment or intimidation. And, the campaign is very deliberate, it's very malicious, and it's designed to harass and intimidate. And, it's not just me making that claim. If you look at this case, the amount of information that's been filed already, Dave has presented his evidence for his claims. And he points out elsewhere in this document that, he's only chosen a fraction of the months of which the defamation occurred for the case of the expedience of the court. Because if he was to list every single incident of defamation, we'd be looking at thousands and thousands of pages of documents here. So it's manifestly neither practical nor desirable for the law to provide a remedy against any and all activity which an individual might find annoying. And so that's fair enough, right? DeFango says I'm fat. Can I really sue DeFango for that? No. But it certainly does seem to violate the terms of service of Twitter and YouTube where, picking on people over a disease is not allowed. And you could argue that obesity is a disease. I don't know, I feel pretty healthy. I don't feel too diseased, so those guys get away with that stuff. But that's an example of finding something annoying, but not quite meeting the standard of a deliberate and malicious campaign of intimidation. But where severe mental pain or anguish is inflicted through this campaign, the intentional infliction of emotional distress provides a remedy. So under New York law, the proper inquiry is not whether each individual act might be outrageous. Rather, the question is whether those actions under the totality of the circumstance amounted to a deliberate and malicious campaign. So this is Rich versus Fox News Network, and this is the Second Circuit Court of Appeal ruling on it. So this is a appellate court judge's statement here specifically about New York law and specifically about what the proper inquiry should be. It's not, is each act outrageous? It's, does the totality of the acts amount to a deliberate and malicious campaign? And is the target of the campaign to inflict the psychological distress? So otherwise, the plaintiffs accepted the findings. And then now the defendant has a civil conspiracy claim, which the magistrate judge recommended to kick out. But his defamation counterclaim has been allowed to survive. And the counterclaim is inextricably intertwined with the defamation claim. And we're going to go into this a little bit more further in this document. So the surviving defamation claims cannot stand without the foundationless underlying civil conspiracy claims. So if the court thinks the civil conspiracy claims are bullshit and should get kicked out, Well, they have to also kick out the defamation because the whole foundation of it is this alleged conspiracy. And in fact, the conspiracy defense that Jason Goodman is mounting in the Eastern District of Virginia, he also thinks that he can apply that to the Southern District of New York, even though the plaintiffs are completely different. The defamation that he made against each plaintiff is completely different. The basis for the cases is completely different. But, despite the presence of Clary Lehman and the Becks and, all these other like superstar lawyers that frequently come on Jason's show, he seems to have a very, very poor understanding of the law and understanding the difference between a plaintiff and a defendant and the difference from one of his cases to another of his cases. He's actually was basically called out by the judge in Virginia for allegedly representing himself as a pro se defendant, and yet actually providing court documents that really did look like they were written by someone else. In fact, in one of Jason's court documents, he refers to himself as her. So either he's a transgender, so we can't. That's a protected class. We can't criticise him for his gender identity, or he's cutting and pasting these legal documents from someone else's case, which he swore under oath to the judge he wasn't doing. So Jason's never explained that female reference in his Virginia case. So the defamation claims should be completely ignored as they are insufficient in providing factual content that allows the court to draw reasonable inference that the defendant is liable for misconduct. So the defendant has a long history of conflating the plaintiff with a group of co-conspirators, joint tortfeasors, related to Goodman's Virginia lawsuit. And in his counterclaim pleading, Goodman seeks to hold Sweigert responsible for statements made by other parties that have nothing to do with the plaintiff. And the plaintiff is nothing more than a convenient target. The defendant should already possess much of the information needed to state a cognizable claim, but he doesn't. And that's true. This has been going on for 2.5 years now. Tons of information has come out, and yet for some reason, Jason Goodman can't actually say what it is Dave Sweigert said about him that was defamation. The conspiracy defamation claims are applied to the plaintiff in a slapdash, incoherent manner. It doesn't meet the federal rules of civil procedure, allowing for adequate notice. So the defendant rehashes a pointless call in a social media podcast show, represents a conspiracy between Frank Bacon, DeFango, and Lift the Veil. No actionable claim is cited. So he's like, these guys spoke on a phone call. But that isn't a claim for defamation. Like, he has to say what was said on the phone call that's defamatory. And if it wasn't said by Dave Sweigert, then what the hell does it have to do with this case in any war? Like, what does it matter? Jason Goodman has defamed Dave. What does it matter what Frank Bacon said on the phone call to Hoax Wars? I mean, it's absolutely ridiculous. Defendant spends 2 paragraphs discussing Tyrone Simpson, aka Frank Bacon, with whom the plaintiff has no contact or association. Again, no actionable claim is cited. Defendant complained that the plaintiff attempted to intervene in the Virginia lawsuit, which he did. He filed a motion to intervene, and it was ultimately denied by the judge. But it's not a tortious act. There's nothing. You're allowed to file motions to intervene, and he had a good case, because if Steele wins, and it's looking pretty likely that Steele's going to win this, in my opinion, the damages initially was $15.5 million, and then it was up to $18 million, and then the last number I saw was, I think, $24 million. And as far as we can tell, Jason's only asset is his Chelsea apartment, which is probably worth a couple of $1 million. So if Steele cleans out Goodman and gets all the money before this lawsuit goes through, then Dave has been unfairly prejudiced by the Virginia court. So that was his basis, is like, look, we've been defamed by the same guy in the same way, and it's a pattern of behaviour. Let me intervene in this court to just, for judicial efficiency, so that we don't have to file this all over America. Let's look and see if can Goodman justify his defamatory statements. In the end, the Virginia judge said, "Nah, too hard. We don't want it. You've got your own case. Deal with it in New York." So fair enough, but that's a reasonable request that was actually to the benefit of the court. It's not something done maliciously to target the defendant. The defendant complains the plaintiff operates a counter-speech blog to defend himself from the defendant's attacks. No actionable claim cited. I mean, he could, if something was said on the blog that was defamatory, Goodman could just provide a list of what was defamatory. He doesn't do that. He just says, this guy runs a blog. Well, there's no law against running a blog. The defendant accuses plaintiff of using his knowledge of military radio communications, essentially glorified ham radio operations, as being used as part of a clandestine network to communicate with co-conspirators. No actionable claim cited. I mean, this is just ridiculous. What does he think, that Dave is like using ham radio to talk to Frank Bacon to get like tips on how to defame Jason Goodman? Whatever. I mean, it's absolutely ridiculous. And then look, here I am. Defendant goes on and on about a non-party Steve Outram in paragraphs 28 to 33. The only logical connection between plaintiff and Outram is that the plaintiff reblogged an Outram post that was almost a year old. Defendant has yet to provide specific tortious acts of a defamatory nature that can be attributed to the plaintiff. So, let's just cut across to this, since it does involve me and I want to address it. So, we have two documents here, 122 and 123. Let's have a look at this document 122, and there's my name. So, Sweigert has worked with, conspired with, cooperated with, or otherwise aligned his goals and actions with co-conspirators in the Virginia case. I mean, like, what's he talking about? That Dave Sweigert worked with Lift the Veil? I mean, does he forget like all these letters to Nathan's mom sent from Fort Meade and stuff like that? I think it's very hard to argue that Dave Acton and Lift the Veil were working together to target Goodman. And, of course, no evidence is presented. The purpose was to destroy Goodman's business and worldwide reputation. Well, I think he's doing a great job of that himself with the complete garbage spewed on his channel, and chill his journalistic efforts. Well, what journalistic efforts? You know, John Benet Ramsey was murdered using a cordless phone. They made a call on a cordless phone. Therefore, it's Dave Sweigert's fault of the murder. This is his journalism. He calls it journalism. People send money for that shit. Sweigert attempted to intervene, was denied. In support of his attempt, several non-parties to the suit submitted declarations in support of intervention. Now, this is a lie. Again, like Goodman he can't help himself. He can't tell the truth to save himself, so he can't differentiate whether he's on a stream or whether he's in a court document under penalty of perjury. But this is a specific false statement he's making under penalty of perjury, which is that several non-parties to the suit submitted declarations in support of intervention. Now, what actually happened is that Jason Goodman alleged this incredible conspiracy theory, and it involved me, Titus Frost, Lift the Veil, Frank Bacon, Leopard Morose, Sugarshine, even I think was named in it, and Kevin Marsden. And some of us, 4 of us, I believe, wrote to the court objecting to Jason's document. Not supporting any document from Dave, simply objecting to Jason, saying that we're conspirators in a conspiracy theory, saying, no, that's absolutely false. If he didn't want me to make a statement to the court saying his claims were false, he shouldn't have made false claims to the court, right? So, anyway, that's just one of many lies here. One of those non-parties was a citizen of New Zealand, Steve Outram. Well, that's true. I'm a citizen of New Zealand. I'm also a citizen of Australia. Outram falsely claims to be, and he spelt my name wrong, falsely claims to be a citizen of California, but this is untrue. Another lie under oath, under penalty of perjury. I've never claimed to be a citizen of California. I mean, is this just targeted to mess up any future visa applications I might have in the United States? I've only ever been a non-resident alien in California with visas legally granted to me. Right? Initially, I had H-1B visa from 2004 to 2006, and then since 2010 to 2017, I resided in California under an EC2 work visa. But my classification is non-resident alien. When I fly into the United States, there's one line for US citizens and one line for aliens. I have to line up with the aliens to come into the United States. I have never, ever claimed to be a citizen of California. And then his basis for the claim is that I gave a P.O. box in California for a filing to the court. And Outram is presently attempting to intervene in this legal matter. Initially attempted to inappropriately communicate directly with Chambers via an email address provided to the litigants by the judge. So what happened is when I wrote to the judge and said, hey, would it be possible for me to intervene in this case? Because basically, Goodman is talking a bunch of shit about me as well and making videos about it, and I want the videos to be shut down. And under YouTube's copyright notification process, if you file a copyright strike and then there's an objection to it, you basically have to take it to court, and you have to provide YouTube with the details of the court. So rather than filing a separate lawsuit against Jason Goodman, I thought, well, maybe I could just intervene in this since it's basically related to this. So I wrote to the judge asking if I could, and the judge made an order, and he said that, yes, under the law, I'm able to do that if I want. But hey, Carl, nice to see you there. Hey, Avery, Mind Inspired. And that's as far as it went. I haven't filed any motions in this court at all. And yet, here's flicking across to this other document, 123, third-party claim verified complaint. Jason Goodman, third-party plaintiff, Steve Outram, third-party defendant. So Goodman's now trying to drag me into this court case, right? And nature of the action, false defamatory statements, false accusations, deceptive actions, menacing cyberstalking, harassment, and deliberate acts of tortious interference carried out continuously through to today. He's saying I became a member of an active conspiracy with Frank Bacon. I mean, that guy fucking hacked me, right? I'm not teaming up with Frank Bacon for anything. And if he wants to sue me for that statement, I'm happy to see him in court because I've got a confession from him on the Steemit blockchain. Outram worked in, and not only a confession, but recently Bacon was called out about that, and in his description of, I didn't do it, he lied. I've got him caught in a lie as well. Outram worked in concert with others to defame, harass, and stalk Goodman. And Outram became aware of Goodman, by his own admission, Outram became aware of Goodman as a result of the Port of Charleston incident. Well, that's completely false. I was watching George Webb from day 8 when he first came out. I remember when Jason Goodman, on the rooftop of his Chelsea apartment, interviewed George Webb for the first time. I tweeted about it. I think I even wrote about it on my blog. So this is easily disprovable. And I was watching the Port of Charleston LARP when they pulled that Operation Clear and Present Danger. I was watching it in real time because I was watching the channel because I was following George Webb. I publish a blog at birders.me. That's true. I publish videos on this channel. That's true. The action is for damages in excess of the minimum jurisdictional limits of this court. Well, Jason Goodman can't show that I have cost him 1 cent in damage. And that's probably why he doesn't state anything here. It's just another load of shit. Mounting controversy exceeds $75,000. Do you know how many Patreon subscribers that is for Jason Goodman? I mean, what's his Patreon? $2. So 34,000. He's got a claim that he lost 34. Well, more than that. So let's call it 38,000. He lost 38,000 paid subscribers because of me criticising the bullshit that he puts on his channel. I don't think he's ever had 38,000 Patreon subscribers. So it's impossible for him to prove this claim. The court has personal jurisdiction over Jason Goodman, the third-party plaintiff, because he resides in New York. I allege to conduct regular business in New York City. Well, no, I don't. I've been retired since 2013, I make videos, I blog, I do philanthropy, but, I don't conduct regular business in New York City. The last time I was in New York, I think, was 2015, when I was going on a cruise from New York to England on the Queen Mary 2, which is where I proposed to my wife. So the whole purpose of being in New York was a personal purpose, and that's my last trip 5 years ago. So there's no jurisdiction, and in fact, the magistrate judge has just completely ignored this filing by Jason in his recommendations because it's obviously a joke. It's inappropriate. Goodman's got everything confused. Outram is believed to be a resident of New Zealand. I mean, he's just said earlier in this thing that I'm a citizen of New Zealand. And so, anyway, look, I don't need to go... maybe I will go through this. Outram spreads known false statements. Well, I haven't spread any false statements that I'm aware of about Jason Goodman. He's welcome to come to my blog to make comments, to correct anything that he believes is false, but he's never had his... give an example of a single false statement? And I'm doing it in furtherance of a conspiracy? What the fuck are you talking about, Objecting to his lies is no conspiracy. In 2018, I published a video interview with Queen Tut. So what? She was an insider on his channel. Hey, Red Pill, nice to see you, mate. Hope you're doing better after your recent hospitalisation. We're all praying for you, man. Queen Tut was an insider on Crowdsource the Truth. And, she, after being featured in an article on Leopard Moreau's, she approached me and said, can I come on your show and tell my side of the story and what happened inside Crowdsource the Truth? And I'm like, for sure, this is an insider. This is a whistleblower who's going to tell us exactly what happened. And she's also a co-defendant with Jason Goodman in the Robert David Steele lawsuit on the Eastern District of Virginia. Along with Trish Negron. And if you go to SDNY.org, and I think actually Leopard Rose has a news story about this. I haven't read it yet, though. But Trish the Dish recently did a thing about Susan Holmes, Queen Tut, and who was arrested by the police for perjury, for the sad case where her son was shot by the cops, and Queen Tut swore under oath that the officer who shot her son was actually the kid's father. Which is a false statement and a lie. And so they dragged her out of her house on a live stream and arrested her. And Trish the Dish did a video about it and neglected to mention that not only does she know who this person is, but they're co-defendants together and were together on Jason Goodman's show, conducting the alleged defamation that's the basis of the Steele lawsuit. In this interview, Outram and Holmes make numerous false statements and accusations intended to defame and harass Goodman. He never says what the statements are. If there's a false statement I made in the show, tell me what it is. I mean, I'm just interviewing someone who was there. And, eyewitness accounts have evidentiary value in court, Who better to say what went on and crowdsource the truth than someone that was involved in it? Holmes makes double hearsay claims, including her belief Goodman has exchanged photographs of himself naked with young girls while on a business trip to the UK with Trish the Dish. Goodman himself has talked about Tinder. He's talked about dating teenagers, which to me, if you have the word teen in your age, that makes you a teenager. So you might say, well, if you're 18 or if you're 19, you're over the statute of limitations. Okay, so perhaps that means that you're not a minor, but you have the word teen in your age. You're a teenager. And then he's also said that he was blackmailed over sending naked photographs of himself, things that would make Anthony Weiner blush. This is Jason Goodman's own words that he said this, and now he's saying that it's defamation because people said he said it. It's his own words. I mean, it's a joke. And then he's saying the false claims by Outram and Holmes were used as a predicate in Steele v. Goodman and Sweigert v. Goodman to attempt discovery of naked photographs of Goodman. This statement is also a lie. First of all, my name is only up in the Steele v. Goodman case in my objection to Jason Goodman bringing my name up in the first place. It is conspiracy theory defense. The judge ruled that I'm not a party to the case. I'm not a party to the case. It's a judge's order. So how can, therefore, my claims be a predicate for this? And I've never been brought up by Robert David Steele or Stephen Biss or, anybody else in the case other than Goodman. So Holmes's claims being used to attempt discovery of naked photographs of Goodman, I mean, I don't know. Who cares? Who would even want to see that, right? But it's nothing to do with me. And then Goodman and Negron have denied these false claims. What false claims does Negron deny? I don't know. And also he said that this was brought up in Sweigert v. Goodman to attempt discovery of naked photographs, but Dave's never tried to get Jason's dick pics. So, yeah, it's just lie after lie after lie. And then we have Goodman going on about how Outram made a false copyright claim which resulted in his suspension, and that I tried to get that added to this case. What happened was I did it, and then YouTube turned around and said that because I hadn't included the full URL to the video, I'd only included like the uniquely identifying letters of the video, that didn't count in their system. So Jason did me a huge favor by filing this document, because in this document he put the full URL to the video that was the subject of the copyright dispute, and I was then able to send that to YouTube and say, look, this is being discussed in court as per your rules. Here's the full URL as per your rules. And YouTube reviewed their decision and gave Jason Goodman a strike. So by filing this document in court, Jason Goodman disabled his own ability to live stream on YouTube for 90 days. And then he's accusing me of doing it. Well, if he hadn't filed this document, it wouldn't have happened. And then Goodman became aware of me after the audience brought social media posts to his attention. I conspired with Sweigert. I completely deny that. I've never conspired with anyone, certainly not Dave, but I'd support Dave because I've been defamed by Goodman as well, as of many other people. Outram took overt action in repeating the lie that Goodman planned, oversaw, and participated in a scheme to perpetrate a dirty bomb hoax. Okay, well, as I've shown before, CNN and New York Times both said that. They both said that Goodman was involved in this conspiracy theory about a dirty bomb. And it's on his channel. His participation in this scheme is on his channel. Anybody can watch it, right? It's not me making up that this happened. He did it. And then he now echoes this, claiming Goodman involvement in an aerial cinematography company is evidence that Goodman had foreknowledge and or some involvement in explosions at a Texas LNG facility. I'd never, ever, ever said anything about this at all, right? So it's just yet again another false claim made by Goodman under oath. And Outram's false allegations of international terrorism. I've never once accused Jason Goodman of international terrorism. Foreknowledge of terrorist events are such heinous false statements. Well, lies, 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 lies. And okay, he's attesting that it's accurate. I point you to this post, this is the thing that Jason objected to. The Able Danger website reblogged this post. And that led to the whole rift between Jason, Field McConnell, David Hawkins, and everything, because Jason wanted Able Danger website to take down my reblogging of this post, and they refused. And why should they? It's a great post. Here is Jason Goodman presenting on a stage as the CEO of Aerocine, the drone company. So this isn't me saying it; it's him saying it. Once again, he says it. And then I repeat what he said, and then he basically is gaslighting under penalty of perjury that, no, I never said that, and Steve's making it all up. And then we can come down again to here. Isn't that an interesting coincidence that Jason Goodman's the CEO of a company operating the world's most advanced commercial video drone? And, I've shown the evidence at the beginning of this post that he was the CEO of this company, that he is actually on stage showing this drone footage as his presentation. Now, whether he was actually the CEO of the company in title at the time of the Maidan Revolution, I mean, I'm not making that claim, right? If you look at, you pass that sentence, the claim I'm making is that the company was flying the drone in Ukraine at the time of it. And that's absolutely established by fact. But if you look at part 3 of this Insane in the Ukraine post, you can go into more detail where I show Jason's involvement with the people that were in the Ukraine operating the drone, including on the day of this revolution. So anyway, let's go back to Dave's case. So going on and on about me, because Dave reblogged that post. And he hasn't provided any tortious act or a defamatory nature that can be attributed to the plaintiff, and no logical claim is cited. So even if you were to take on face value everything Jason said was true, that my post is just a bunch of lies trying to frame him as an international terrorist, what's that got to do with Dave? Jason has to make specific allegations of how Dave has defamed him so that Dave is able to respond and defend himself to these defamation allegations. Now we have the plaintiff's intentional infliction of emotional distress claim. which the magistrate judge recommended these allegations be dismissed. But the law suggests, and the circuit suggests, that when the totality of circumstances is examined, the claim should be left disturbed. And if not, the plaintiff should at least be given leave of the court to amend and clarify his claim so that it can reflect the totality of the circumstances, namely events and activities that can be compartmentalised into a working definition of smear campaigns. On undisputed facts, on many prior occasions in this and other federal courts, Goodman alleged plaintiff is a member of a group of co-conspirators that orbit around Robert David Steele. Now, his brother, George Webb, he definitely knows Robert David Steele. He met with Robert David Steele the day before they launched their Operation Clear and Present Danger LARP. So we can definitely connect George Webb to Robert David Steele. There's no question about that. And it's interesting that Webb is not a defendant in Steele's case against Goodman. However, just because his brother did it doesn't mean that he did it. Like, there's no connection between Dave and Steele. Defendant Goodman, not the plaintiff, had direct communications with Steele via a social media podcast to raise funds for Steele's entity known as Unrig a day before the infamous Port of Charleston dirty bomb hoax. So the connection that Goodman's alleging, he's alleging that Dave Acton is connected to Robert David Steele. It's actually him. It's him that has this connection. So, projection again. The defendant states, almost immediately following the incident in the Port of Charleston, Sweigert began parroting the claims made by Steele, publicly demanding the FBI investigate Goodman for his role in the alleged dirty bomb hoax. Well, the FBI should investigate him, and why haven't they investigated him? Why is it that he can shut down a port and get in absolutely no trouble? Why is it that when he's, filming for the stories about the Las Vegas massacre, he can go to a 7-Eleven or gas station, whatever it was, and, climb on the roof of it, trespassing and never get in any trouble? Why can he make all these false statements under oath and never get in any trouble? Well, perhaps it's related to the fact that he has so many people on his show who are former FBI, FBI informants by their own admission, former CIA. It's like there's a lot of deep state people who go on Jason's show, and this case was transferred to, the general counsel of the FBI, who's now a judge, right? But anyway, I am quite happy now to say again, 2.5 years later, the FBI should investigate Jason Goodman's role in the alleged dirty bomb hoax, right? You shouldn't be able to do this. And this attack on critical infrastructure, probing the defences of our ports, also led to seems to have been connected to a viral attack on the Maersk shipping line, originated out of Ukraine 2 weeks later. And by viral, I mean a cyber virus. There was an electronic virus attack on the Maersk shipping line. Now, was that something that happened during the port shutdown, that they were able to get inside the Maersk systems and implant an electronic virus? I'm just speculating, but the people who did this, I consider them to be bad actors that do not have the best interests of the United States at heart. So, setting aside the statement that the fact that the statement is false, that Sweigert didn't parrot Steele's claims and demand FBI investigate Goodman for the role in the dirty bomb, the defendants now had 30 months to locate the statement on social media platform. The statement is the height of Vegas. Not even a medium has suggested, whether it's television, radio, blogs, Facebook, or whatever. He's just making this vague statement, and he's had 2.5 years to get a specific statement. You think by now, given how important this lawsuit is to him, that he would have worked this stuff out. So finding no such statements made by the plaintiff, then the defendant has to attribute statements made by Steele and the other joint feasors to the plaintiff. Right, so he's basically blaming Dave for what Steele and his gang said. Sworn statements have been provided by numerous parties in other federal courts debunking the defendant's claims that plaintiff is linked with these tortfeasors. Nonetheless, the defendant continues to ignore the sworn statements and distributes his smears against the plaintiff. The court should be fully aware of Goodman's policy and practice of attributing defamatory statements made by other third parties to the plaintiff. Well, I just showed you that in my document, their document 123, Jason's third-party complaint against me, where he's blaming me for statements made by Queen Tut or by himself, right? I mean, this is a deliberate and methodical pattern of behaviour. He just keeps doing it again and again and again. And you have to wonder, is it really just because of just pure stupidity and ignorance? or is it malicious? Is it part of the plan? Then we move on to the Black Cube coffee cup. So the defendants used his conspiracy theories as justification for creating this deplorable merchandise sold on Redbubble.com. And remember that the magistrate judge has, agreed with this and allowed this to go through in his recommendation. The merchandise was an integral part of the multi-year smear campaign. It was the alleged slander of Chavez and Steele in November 2017 that led to the creation of the Black Cube coffee cup. Right, so this whole thing about Jason Goodman being in Black Cube, let's have a look at the timeline of events. We flick across to this Twitter here. Steve believes Lapwaz, being Defango, of course, believes Matt Couch and Frank Bacon. I didn't believe either of them and made sure to drop their names later on so people had a full understanding of where the information is coming from. This is a complete lie from Defango. It's only on Twitter, so it's not under oath. But we've basically traced how this information has come. That Matt Couch sent a private message to Defango and said, "Don't make this public." And Defango then went and posted it on Steam It. He did a show with Dave Acton. He got Dave to call in, and then he made the statements on the show with Dave, basically trying to associate Dave with these complaints and smears. And then the information later appeared on 4chan. So we can't prove that Defango posted it on 4chan, but it's kind of amazing to watch how this information has come out. And I said, my story illustrates how you took the information, tried to use Dave to legitimise it, embellished it in a Steam It post, details of which were then reproduced by someone on 4chan. And so here's the message here, and I've got, I think in the comments of the show, I've got links to these tweets if you want to go through this whole LARP Wars thread that I've got there. But so November the 21st is when Matt sent Defango this message. Do not tell anyone how you got this information. And he says that the information came from a CIA person in his team. Now, I know who that person is, and I've actually had the identity of the person sent to me by a couple of independent people, and I've also had it verified by a trusted source who would be in a position to know. So I'm not going to reveal that, but just think about that. Like if I know who Matt's source is, there must be a lot of other people out there who know who it is. And Matt's been basically demanded to reveal his source in court. And I, if he's watching this, I really would recommend he do it. It's not worth putting yourself, your family at harm and an economic risk to protect the source when the information is known out there anyway. And I think actually his source would probably agree with Matt if he were to contact him. But I really admire Matt for taking a principled stand on this, and I think he's done phenomenal work investigating Seth Rich. It's a shame for him that he got caught up with these characters. And then so that's November 21st. The very next day, Defango interviews Dave and shares this intelligence. And it shows up on Steam It, and then in December it shows up as this anonymous post. Here's the Steam It post. Just a little trick with any post that is on Steam It. If you put .json at the end of the post and type it in, it comes up with all the code of the post, and you can get the creation date of the post from inside that code. So Steam It makes it hard for you to know exactly when a post was posted, but if you put .json on the end, you can find that out. So November 23rd. So the 21st, Defango gets the information from Matt. 22nd, he tries to associate it with Dave Acton. 23rd, he posts it up on Steam It. And, it's basically showing how the intelligence community, because this came from a CIA source, right? They're laundering PSYOP information by sending it to truthers, who then repackage and broadcast it, 4chan, Steam It, Twitter, and YouTube. And along the way, embellishments get added, like Jason was in the Sony leaks, which, I've searched the Sony leaks for him from WikiLeaks, and it's he's not in there. So now, interestingly, if we're to trace the source of this Jason Goodman is Black Cube, Jason Goodman is Mossad rumor, it basically comes from George Webb, that as George and Jason were driving to Jerome Corsi's house to have a meeting with him in his home office, George said to Jason, "You have become an unwitting Mossad operative." And Jason's like, he didn't deny it or anything like that. He just looked a bit like stunned and shocked by it. And then at this meeting, allegedly, this is according to George Webb, both he and Jason were offered $9,000 a month by Jerome Corsi to join his team as sort of like roving reporters. They then got a gig where they appeared on InfoWars with Mike Cernovich shortly after that. Now, Corsi, I'm not going to play the clip here, but I will put a link in to the comments later. On No More News, they have a clip of Jerome Corsi calling into InfoWars to Alex Jones and saying that his information comes from above Mossad sources in Israeli intelligence. We've also got Larry Klayman, Jason's good legal buddy. He has court documents where he said that he gets intelligence from sources in Israeli intelligence. So if you're following that stuff through, that Jason says that Goodman's an unwitting Mossad helper, and then Goodman and Webb get on the payroll of Corsi, and Corsi's getting his information from above Mossad sources, then, this claim that Jason is getting paid by Black Cube it's actually not that ridiculous. It's actually kind of plausible. There's evidence to suggest that that's, someone could make a reasonable inference of that claim being true. But regardless, there's nothing about that claim that came from Dave Acton. So they're saying that the plaintiff has libelled Goodman by saying he's a paid operative of a private associated firm of Black Cube. And then the release of the slander by Chavez on a social media podcast caused Goodman to create the Black Cube coffee cup. And he made a coffee cup for Robert David Steele, one for DeFango and one for Dave. So the claims for defamation are misplaced on the plaintiff and should be placed on the group of joint tortfeasors. So first of all, hey, you get paid by Black Cube. Is that really defamatory? Leaving aside the thing I just said about that's possibly true, just assume that it's false. Is it defamatory? Does it cause financial harm to Jason Goodman? It's kind of hard to argue that, I think. But regardless, Dave never made that claim. DeFango made that claim. Why isn't Goodman suing DeFango for defamation if he thinks that this is so defamatory? And then the humiliating Black Cube coffee cup was an integral part of the Crowdsource the Truth podcast show and only one piece of an overall smear campaign designed to inflict emotional distress. In the screenshot below, note how the Black Cube coffee cup is positioned. So there's Jason, there's his laptop, and there's his coffee cup placed, well in front of the laptop and angled in the shot so that you can see Dave Acton's face. It hasn't come through too good on my screen, but in the PDF document you see that a bit bigger, with a duncer's cap on. Now, Jason Goodman is a professional Hollywood guy. He made movies with Bryan Singer, notorious Hollywood pedo. And he knows all about cameras and angles and shots. This is his professional career before becoming this YouTube larper shutting down ports and stuff. So it's hard to argue that this is just accidental, this placement. I mean, look where he's sitting. He's not a very tall guy. He doesn't have long arms. He can't even reach that coffee cup, from this broadcast. It's a very, very strange angle to have your cup of coffee if you're drinking a coffee while you're making a stream. But it's exactly the angle you would get if you wanted to deliberately display the coffee cup. So, intentional? Absolutely that's intentional. There's nothing accidental about that. And, interesting to note that there's Larry Klayman on the show where they're basically launching this attack. And, here's the Dave the dunce, DeFango the pig's ass, and Robert David Steele the horse's ass. This is their artwork with Redbubble. There's Jason, showing it, making sure that the likeness is clearly displayed while he drinks out of it. And so it's basically coming out in the Virginia court, and DeFango's had his subpoena stream where he was subpoenaed for information, so released all these emails. We know the source of this rumor now. It came directly from Matt Couch, from the CIA source and his team, and then it was broadcast by DeFango. So not only has this come out in court, but Jason Goodman is extremely aware of it because it's come out in his own court case, right? from Jason's own court case. He knows that this information did not come from Dave Acton, and yet he persists with the claim. So the Redbubble was part of the smear campaign. At the time the merchandise was released, the defendant broadcast that the plaintiff was a member of the deep state and associated with a CIA guns for drug smuggling in Latin America while he served in the Air Force. He was involved in the defendant, Goodman, specifically made the statement that Dave was involved in an aircraft crash in Nicaragua in 1983 and most likely had post-traumatic stress disorder. So he's acknowledging that he thinks the guy suffers from PTSD, and therefore he is presenting information designed to trigger that PTSD, right? I mean, how much more intentional can you get? PTSD, that's emotional distress. It was a direct attack on a perceived emotional condition that would be impacted by the display of crashed aircraft in Nicaragua in 1983. And the artwork is designed to mimic the news, I think that's on the next page, this artwork, surrounding an aircraft crash. A pre-planned direct attack on the emotional stability of a PTSD sufferer, directed squarely at the weakness in the hopes of triggering an unstable emotional episode, planned and intentional. And so here, look, Crazy Dave, accusing him of mental illness, associating with Oliver North, who pled guilty and was then later pardoned. But, he pled guilty to this Iran-Contra, drugs for weapons scandal in Nicaragua. And then Goodman, I consider this is his letter to Redbubble, consider this a very serious matter as it deals directly with the First Amendment right to freedom of speech, freedom of the press, as well as important elements of the Digital Millennium Copyright Act and other laws including fair use and parody. The complaint seeks to circumvent matters currently under consideration in the SDNY. So the defendant, Goodman, is specifically saying that he thinks that he has the right to, basically publish dunce coffee cups mocking people, triggering them over their PTSD. He has the right for that under free speech, but that's already been established, by the judge there in the earlier the magistrate judge's recommendations that no, you don't have the right to use someone's likeness for commercial purposes without their permission. I mean, that seems a pretty basic area of the law, right? But Goodman obviously doesn't know that either. The defendant believes he has some right to conflate the plaintiff into any number of defamatory conspiracy theories at his whim. The widely distributed artwork places him in the Iran-Contra scandal, and the defendant knew that he was held in enemy captivity for 48 hours by the paramilitary Sandinistas while they were ferrying a helicopter from Panama to Honduras. The aircraft crew was on loan, a temporary duty assignment to the Organization of American States for peacekeeper missions. And then to further trigger the memories of the crash, they changed the date of the aircraft crash listed as from October 6, 1983. In fact, it was reported in the New York Times as October 6, 1986. It's a direct assault on him to trigger memories of the aircraft crash and the 3-year manipulation of the date so that it would then coincide with the plaintiff's military service seems an overtly outrageous act for a news organisation to commit. He can't claim that Crowdsource the Truth is a news organisation when they basically are lying about dates just to smear and slander people. Report the facts. You don't change years from a news report just because it suits your narrative, unless you're a LARPer. Such manipulation of historical facts and news events that target an honourably discharged veteran to manipulate PTSD injury, extreme and outrageous conduct intended to cause or disregard a substantial probability of causing severe emotional distress, with a casual link between I think that is probably supposed to be a causal link between the conduct and injury causing severe emotional distress. And again, this Rich versus Butowsky second cert of appeals thing is cited. Now, let's actually just jump across to that. How am I going for time here? Okay, good. So this is the Joel Rich and Mary Rich versus Fox News Network, Malia Zimmerman and Ed Butowsky, and this is the Second Circuit Court of Appeals. So let me zoom through this to the relevant part where it's in the ruling. hang on, what's this? Procedural background. Okay, no, keep going. Discussion. Here we go. So, there's 3 questions of New York law that the appellate court's considering. 1, whether the allegations in the complaint suffice to state a claim for intentional or reckless, extreme and outrageous conduct against the riches. So, and the court has held that, yep, they do. 2nd, whether the complaint plausibly alleges that the appellees tortiously interfered with the contract between the Riches and Wheeler, and they held that, yep, it did. And then 3rd, whether the Riches satisfactorily pleaded negligent supervision or attention against Fox News, and they decided not to rule on that. But here we go about the intentional infliction of emotional distress. And look, in my opinion, the things that were said in this case against the Riches, were perhaps not as bad as the things that have been said by Jason Goodman against Dave Sweigert. But there's certainly similarity. If your kid gets murdered, you're going to have PTSD. And so someone's making YouTube videos about your kid getting murdered, is that designed to trigger the PTSD? So here's the New York restatement. New York has adopted the restatement 2nd formulation of intentional infliction of emotional distress. One who by extreme and outrageous conduct intentionally or recklessly causes severe emotional distress to another is subject to liability for such distress. The broad definition is both a virtue and a vice. The tort is as limitless as the human capacity for cruelty. The price for the flexibility in redressing utterly reprehensible behaviour is a tort that by its terms may overlap with other areas of the law, with potential liability for conduct that is otherwise lawful. Therefore, it may only be invoked as a last resort to provide relief in those circumstances where traditional theories of recovery do not. So under New York law, then the claim requires a showing extreme and outrageous conduct, intent to cause or to disregard the probability of causing severe emotional distress, and a causal connection between the conduct and injury and severe emotional distress. So it seems to me that Jason Goodman's behaviour fits all of those, that it's extreme and outrageous, the conduct, and not just about the helicopter, but many of the other things that he said as well. There was an intent to cause it. I mean, he's acknowledged that. He's specifically mentioned the target, that Dave is probably suffering from PTSD, so he's aware of it. A causal connection between the conduct and injury. Well, if you have PTSD over a helicopter being shot down and someone's showing things about a helicopter being shot down and lying about the years of it, that seems to be a connection. And the severe emotional distress. Well, that's the sort of thing that I guess should be argued in court rather than me offering my armchair opinion on it. The disagreement hinges on the first prong. That's what they focus on. So the Riches argue that we should view the specific allegations as a series of acts that, taken together, constitute extreme and outrageous conduct. So even though each individual allegation on its own might not be sufficient to be outrageous, taken together, the acts amount to a deliberate and malicious campaign of harassment. So this because this has been ruled by the Second Circuit Court of Appeals, this is now case law. This is a legal precedent that if you do multiple acts in a deliberate and malicious campaign of harassment, that can be just viewed as extreme and outrageous conduct by a court. And the Riches allege that the appellees knew of the susceptibility to emotional distress. Dave's alleging that too. And the conduct was extreme and outrageous when they proceeded in spite of that knowledge. Dave's alleging that too. We thus conclude that under either theory, the Riches sufficiently pleaded extreme and outrageous conduct. So this will be very interesting if the judge is going to go with her magistrate judge's recommendations, or she's going to go with the ruling from the Second Circuit Court of Appeals. And I would say she's going to have to go with the appellate court, because if she doesn't, then it sets it up for an appeal. And if the appeal goes to the same court over the same issue, I don't know that they're really going to look that greatly on something like that. So the merchandising, the Red Bubble, was initiated in retaliation for a discrete event. The slander, and it's incoherent and implausible that a news organisation would intentionally manipulate facts to perpetrate a known slanderous falsehood for the purpose of selling a small quantity of actual merchandise. So, although Goodman was profiting from the slander, that in itself isn't enough to explain why he did the slander in this particular fashion on this particular, perceived weak point of the plaintiff. And then we're moving on to the other claim, the continuous conflating of the plaintiff with the co-conspirators. It's well documented that a rogue group of social media agents of chaos targeted Goodman, according to the former insider whistleblower that was attached to the joint tortfeasors, Defango. Beginning in May 2019, defendant has conducted extensive public phone calls with Defango to discuss the conspiracy. And then Defango provided messages to the defendant that exonerated the plaintiff from any membership with these joint tortfeasors. This is a key piece of information. We know that Jason Goodman has received proof from Defango that shows that Dave Acton wasn't involved in this stuff in any way. Right? Thomas Schoenberger, Well-Traveled Fox, Trevor Fitzgibbon, Ed Butowsky, Matt Couch, Manuel Chavez, even Frank Bacon. These people, the evidence shows these people were communicating with each other in relation to these types of matters. But it doesn't show anything about Dave. So Goodman knows that, and he's carrying on with these arguments anyway. It's not just that he doesn't have evidence and he's making arguments without evidence. He does have evidence. He has evidence specifically contradicting his own claims, and yet he continues to proceed with this. Below is depicted only one of dozens of electronic mail messages sent from Chavez to the defendant, describing all the players involved with the joint tortfeasors. So this is one from Tanya Biss, saying that Robert Steele moves too fast, thinking that Defango should have his case against Jason Goodman, talking about Nora Maccabee's brother Max, that Stephen Biss defended, I think. These people are all connected to David Brock and Pizzagate and all that stuff. Nearly every possible actionable defamatory statement attributed to plaintiff by the defendant in this claim 122 was made by this group of joint tortfeasors, not the plaintiff. Goodman has attributed the statements to the plaintiff that have been made by them, not associated with them in any way, but associated with the Virginia lawsuit plaintiff, Steele. Steele's attorney, Biss's wife, Tanya Cornwell, and Biss's friend, Chavez, and former business partner of Chavez, known as Thomas Schoenberger. On December 2017, this is what Goodman is claiming. He's saying that Sweigert entered a verbal agreement with Simpson during a multi-party telephone call, and then through his interactions and communications with surrogates, co-conspirators, and intermediaries, including his own brother Webb, Chavez, and Simpson, Sweigert has aligned his efforts with those of the plaintiff in Steele versus Goodman. Webb, Chavez, and Simpson have each communicated directly with Steele on multiple occasions. So what? So what if they all communicated with Robert David Steele? What has that got to do with Dave? How can you think that has anything to do with Dave? Chavez claims Simpson is the brother-in-law of Steele's attorney, Biss. I don't believe that to be true, by the way. Sweigert attempted to intervene, but that was denied by the judge. So what? What's that got to do with anything? And this conspiracy that he's talking about is the Hoax Wars Christmas show. Frank Bacon, he's always promoting Steemit. He's saying, hey, Dave, you should get on Steemit. Dave's like, oh, okay, maybe I'll get on Steemit. That's the extent of it. It's a blogging platform where if people like your posts, you can get rewarded in Steem cryptocurrency. That's it. Now, I use WordPress. Dave's website, SDNY.org, that's also done on WordPress. Tracking the leopard morose, that's also done on WordPress. So therefore, does that mean that Dave, Leopard Morose, and I are co-conspirators because we all use WordPress? Of course it doesn't. 80 million people in the world use WordPress. It's not like 80 million people have teamed up to defame Jason Goodman. So likewise, the argument that using Steemit makes you a co-conspirator with other users of Steemit is just absolutely ridiculous. But that's all Goodman's got. He's really got no basis to actually defend his behaviour. So that's why he's come up with this elaborate conspiracy theory, which, he's yet to provide evidence of in all these different cases. He can't prove this in court. Now, the collusion between Biss, Steele and DeFango, trying to set up a lawsuit from DeFango. Well, that lawsuit was never filed either, so that doesn't seem particularly relevant to Goodman's defamation of Steele. So I don't think he's going to get very far with that. But in this case, it has absolutely no relevance at all. So here is the parties that Goodman has claimed are involved in this. The plaintiff in Steele versus Goodman, Robert David Steele. The counsel for the plaintiff, Stephen Biss. Co-defendant, Patricia Negron. The counsel for the plaintiff, Biss's wife, Tanya Cornwell. And DeFango. DeFango has at least I think it's supposed to say year, history in social media circles of providing social media reputation protection for paid clients. And in podcasts, he's admitted to working with Stephen Biss. And that's like, he has said that Biss was his attorney. And we also have Biss on a recording saying that he's DeFango's attorney. Now, he's not representing him anymore, but around the time that this all went down in mid-2017, Tanya paid incentives and monies to Chavez at least $1,500. And she admitted to drafting a pleading for the signature of Chavez to act as a plaintiff. According to Thomas Schoenberger in a recent video, Stephen Biss's office spent about a week of time developing this complaint for DeFango. And he got cold feet when he realised that if he filed it, he would be subject to discovery, and then people could maybe find out some of the stuff that he'd been up to. And so he chose not to find it. Now, he's also making the claim that in his subpoena compliance stream, he handed over every email that he'd ever received. That claim has been proven to be false by DeFango, who recently uncovered a whole bunch of other emails from his days at Fireside. So, all this stuff from the Virginia case really has no relevance in the New York case. Then the client of Biss Steele paid Chavez $500 for unknown services. So, DeFango's getting paid by these people. DeFango's the one saying Goodman is Black Cube. And DeFango is the one, getting Dave on the phone to talk about the story and trying to get, Dave attached to it, which failed. And then we go on to the news reports. If you haven't seen the story from both Raw Story and the Daily Beast about Fox News reporter and right-wing conspiracy theorist plan to wiretap the family of Seth Rich. This is Will Sommer, one of DeFango's Q-Slayer gang, who appears to maybe have turned on DeFango in publishing this story. Okay, we don't need to go through that one again. But here's lawsuits related to Butowsky, Bauman versus Butowsky, Butowsky v. Gottlieb, Rich et al. Versus Fox News et al., Rich v. Butowsky, Rich versus Fox News. Butowsky paid $20,000 to Chavez and other pseudo-political operatives like Thomas Schoenberger. That would include the well-travelled Fox and Trevor Misgivings. Butowsky was a Fox News contributor. And the Seth Rich conspiracy attracted intense attacks by conspiracy theorists that leveraged social media as a public relations weapon, as in weaponized. And I think there's good evidence for that, that of all the various psyops flying around with Seth Rich. And, so many of them, Jason Goodman was involved with, Rod Wheeler came on his show with George Webb. And also, of course, DeFango was involved with. So the source is Chavez and Schoenberger. They went to Dallas. And the events occurred precisely during the same time period that Goodman complains of plaintiff joined this confederation with them. Plaintiff had nothing to do with these individuals, their plans, their initiatives, or these events. And Goodman has not attributed a single defamatory statement made by plaintiff during this time period. So Goodman's saying that Dave said stuff that was said by DeFango. That's basically the essence of this. And, Dave Sweigert and Thomas Schoenberger have nothing to do with each other. Both men have made those statements repeatedly. They don't know each other. They've only even encountered each other related to this case and related to DeFango's actions. I have evidence from both parties saying that proving that they don't know each other. They didn't know each other as recently as, mid last year. And I have actually offered to Dave if he'd like that evidence, and so far he hasn't asked me for it because It's not relevant to his case. It means nothing, Whatever Thomas Schoenberger says or Manuel Chavez says has nothing to do with Jason Goodman's defamation of Dave Acton. It's as simple as that. None of these activities have to do with the plaintiff, confusing attribution of defamatory statements, and then, because the defendant is basically conflating all of these statements together, it makes the identification of sources of the alleged defamation problematic, vague, and ambiguous. For instance, Goodman considers positive book reviews of the plaintiff's book to be actionable. I mean, but he doesn't even state what positive reviews they are. It's just like, you can't have good reviews of your book. That's defaming me. Like, this is absolutely ridiculous. The conclusion is unsupported with any facts or evidence, just slapdash envisaged generalities. This is what Goodman is saying. Sweigert's co-conspirators engage in overt acts in furtherance of their conspiracy, providing positive views of the book intending to bolster sales. I mean, if you like a book, you're allowed to give it a good review. And, this is kind of the essence of this case and of other cases. Like, Jason Goodman believes that if anybody criticizes him in a live stream or in the comments to his YouTube account, that person is not just a troll, but part of this organized army of trolls being sent out in a conspiracy to defame him. He can't accept that when you say things like, the population of the earth is or the extraction of oil from the earth is causing its rate of rotation to be slowed down on your show, that people think that's bullshit and might write a post pointing out the actual logic of the physics of why that's bullshit. He doesn't think there could ever be a genuine complaint. He thinks that any complaint at all is a conspiracy against him. And this is what he's arguing in a court of law. I mean, it's a ridiculous thing. Positive book reviews are a conspiracy. And then Goodman says that even this lawsuit, it's only one component of the defamation and harassment against Goodman. Again, no specifics are provided, merely a conclusory opinion. Goodman says Sweigert's made numerous false statements of false accusations in furtherance of the conspiracy, including contacting law enforcement around the country and providing false statements intended to put him in jeopardy of criminal charges. So such an allegation sounds in the common tort of malicious prosecution. It's not defamation. The plaintiff hasn't received adequate notice as to what statements are being prescribed and to what law enforcement agencies. And so the court and the plaintiff are left hanging. The rules of procedure are stood on their head. And then continuously conflating of the plaintiff with the Port of Charleston. Dave's lawsuit against Jason Goodman actually doesn't have anything to do with the Port of Charleston LARP. It has to do with defamation. But anyway, we've got it in. It's the New York Times. It's CNN. It's quite reasonable for anyone to consider this as a conspiracy theory and a hoax if that's what these organisations are saying. Here's the book in question. And there's a big disclaimer on the book. It says, this document provides a threat assessment of a cyber attack vector. Individuals listed in this report should not be considered guilty of any crime or offence. The focus of this document is to present evidence of the telecommunications aspects of the dirty bomb alert and warning received by the Coast Guard on June 14th, 2017 in the context of federal law. Any individual discussed should be presumed innocent of any crimes until adjudicated otherwise in an appropriate court of law. So Jason Goodman's taking this clear statement saying that nobody involved should be considered guilty of any crimes and gaslighting the court and saying, the book says that I'm guilty of crimes. It's, again, ludicrous. It's hard to fathom how an Amazon book with such vivid disclaimers could be considered an artifact that accuses the defendant of a crime. So, Dave has professional qualifications to write about this type of stuff, and from his experience in trading, he wanted to inform the captain of the Port of New York and New Jersey about the defendant's activities, and so he wrote a letter to the Coast Guard, letting them know what's going on. And notice that Marcus Conti did a LARP video when the Maersk Memphis was coming in New York, saying similar things to what Goodman has said, like Maersk Memphis, dirty bomb, and stuff like that. These guys seem to be testing and probing the critical infrastructure of the US, and the ports seem particularly vulnerable. And then Goodman says the letter in the information in the letter is false. He doesn't say what's false. It's just still vague, ambiguous, and conclusory allegations that cannot be proven. So, and then we move on to the legal arguments here. And look, I don't need to get into the nuances of this. This is for the court to describe. But basically, Goodman's statements are insufficient to state a claim for defamation. The plaintiff has little or no idea what specific defamatory statements Goodman is referring to. So if you're going to accuse someone in a court of law of defamation, you have to be prepared to say, here are the defamatory statements. And if he can't produce it, why should the claim even be considered, particularly at this late stage of the proceedings? The mere allegation that defamatory statements were made to another unidentified residency program is too indeterminate to provide sufficient notice of plaintiff claim so that the defendant can prepare their defence. So this is case law that Dave is citing of why basically Jason's counterclaim should be kicked out. The court must decide if the defendant can supply any evidence that could be used to support his outlandish claims. I mean, he hasn't so far. The court should consider whether it's even possible to obtain evidence during discovery to support this. I mean, if Dave never said this stuff about Jason because it was all said by DeFango and Robert David Steele and others, then, what's discovery going to do? He never said these statements in the first place. So, it's just wasting the court's time. And then here we go. The bulk of the defamation claims are time barred. Concerning any defamation allegations related to the book, they're presumed to be time barred as the book was published April 14th. I think that's supposed to be 2018 there. It's a bit of an unfortunate typo. And here we go. Yeah, April 14th, 2018. The statute of limitations in New York for defamation is 1 year from the date of the publication. Under the single publication rule, a reading of libelous material by additional individuals after the original publication date does not change the accrual date for a defamation course of action. The accrual date remains in time for the original publication. So, Jason's bringing up the book, saying that the book is defamatory, but he didn't make that claim in time within the 12 months. So it's outside the statute of limitations, and New York State does not allow extensions of the statute. And then this report again. I think I really have gone into this in quite a lot of detail, but the intentional infliction of emotional distress, coincidentally involving Ed Butowsky, the employer of Manuel Chavez, it's basically saying that under New York law, although the standard of outrageous conduct is strict, rigorous, difficult to satisfy, that's not the case when there's a deliberate and malicious campaign of harassment or intimidation. It's manifestly neither practical nor desirable for the law to provide a remedy against any and all activity which an individual might find annoying, but at the same time, where severe mental pain or anguish is inflicted through a deliberate and malicious campaign of harassment and intimidation, IIED provides a remedy. In other words, under New York law, the proper inquiry is not merely whether each individual act might be outrageous, rather the question is whether those actions under the totality of the circumstances amount to a deliberate and malicious campaign. The total of circumstances weighing against the defendant is staggering. The defendant openly admits he was aware of the plaintiff, and in fact, before the infamous tweets, "Dirty bomb, Memphis Merc, please investigate," the defendant spent 3 minutes discussing plaintiff's purported involvement in CIA drug running in Latin America. The slander and defamation began June 14th, 2017 and has not stopped. It represents a multi-year smear campaign directed specifically at the emotional health of the plaintiff. The court should also consider how the defendant tried to exploit a known emotional weakness over his PTSD. Conclusion, the administration of justice does not seem served by providing Goodman a blank check for any slapdash conspiracy de jure. That's a word, it's sort of the opposite of de facto. It means conspiracy as recognised by the law, even if it doesn't exist in reality, against the plaintiff without relevant evidence of a coherent theory to back those accusations up. The court should consider the practical effects of sustaining the allegations of defamation without any kind of specificity. Otherwise, the plaintiff is placed in the position of continuing to play whack-a-mole each time the defendant tries to launch another allegation related to a perceived co-conspirator or joint tortfeasor. The magistrate judge may have erred by allowing the incoherent and implausible conspiracy defamation theories to stand because the defendant has not produced any linkages between the perceived defamatory statements and conduct attributed directly to the plaintiff. They're attributed to third parties that have nothing to do with the plaintiff. His claim should not be allowed to stand in the counterclaim. He spends 2 paragraphs discussing Frank Bacon. So what? Goes on and on about me. So what? The defendant is preoccupied with third parties and has no real defamations against the plaintiff. This court should rightly ask the defendant, where's the defamation beef? Meanwhile, the defendant's counterclaim for defamation should be dismissed in its entirety with prejudice, without leave to amend. And then, bringing attention to the Second Court of Appeals ruling, which seems to fit. All right, so... yeah, I mean, that's kind of where we're at the case. It's going to be interesting to see what happens. I mean, we've got... I believe the procedure now will be the presiding judge, Valerie Caproni, will consider this document and consider her magistrate judge's recommendations and decide what goes forward and what not. The worst case scenario for Dave is that this counterclaim from Goodman stands, but, Goodman still has to prove that claim. He has to prove it and prove that damage was done and has to provide evidence. And, talking about what Frank Bacon and me did is not going to convince anyone because it's got nothing to do with the case. So thanks everybody for tuning in. Appreciate you guys very much. And I'll keep you posted as more things happen with this case in the future. Have a good day, everybody.